And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, and loving life. We're back again with part 3 of birth certificate bond for indemnification. And so we're going to continue on with what we had earlier, the final part. And we are going to start out by talking about sovereign immunity. And again, Cornell law, sovereign immunity, definition. Sovereign immunity refers to the fact that government cannot be sued without its consent. And what I'd like to point out here is under Article 9 and Article 10 of the Constitution, the United States doesn't have any powers any greater than the people. So therefore, this is equal in our right to not be sued without our consent. Sovereign immunity was derived from British common law doctrine, based on the idea the king could do no wrong. In the United States, sovereign immunity typically applies to the federal government and state government, but not municipalities. Federal, and there are other exceptions as well, we'll find out here. The federal and state governments, however, have the ability to waive their sovereign immunity. The federal government did this when it passed the Federal Tort Claims Act, which waived federal immunity for numerous types of tort claims. And before I continue any further, I forgot to let everybody know, remind everybody, please hit that like, share, and subscribe button. There's a PayPal link down there for anybody that wants to share some love. And the StreamYard link is pinned for anybody that wants to join the panel. Greetings, Rebel. How you doing tonight? Okay, maybe he's not there yet. So let's get back to it then. It says various considerations related to federal immunity. Under the Ferry's doctrine, those who are injured during their military service cannot sue the federal government. Under the Westfall Act, federal employees cannot be sued for torts committed during the scope of their employment. Citizens suing their own state. When determining whether a citizen may sue a state actor, someone acting on behalf of the state, example, a state worker, courts will typically use one of 4 tests. Government versus proprietary function test. Was the actor functioning in a governmental fashion or a proprietary fashion? If the actor was performing for a proprietary function, example, acting for financial gain for itself or its citizens, doing something that is not historically a governmental function, doing something that can be performed by a private corporation contractor, then the actor is subject to liability. And like we saw earlier with Tiffany Henyard of Dolton, Illinois, she has no immunity, none whatsoever. That's what that's talking about. If the actor was performing a governmental function, an example, acting for the general public, doing something ordained by legislature, performing a historic government function, then the actor is not subject to liability. And what she was doing was taking government funds and using them for personal travels and fundraisers and things like that. That's not appropriate. Ministerial, operational versus discretionary functions acts test. Was the actor performing a ministerial or operational task or a discretionary task? If the actor is performing a ministerial or operational act, then there is no immunity. 32 CFR 1602.4 Area Office. The Selective Service Office, which is responsible for all administrative and operational support for the one or more local boards within its jurisdiction. We got Goldsmith with us again tonight. How you doing, brother?
Hey, how you doing, Keith?
Good, good. Are you familiar with any of the sovereign immunity stuff, brother?
Not really with the laws on it. But with the word, I know that I commented earlier. Sovereignty is granted by the king.
Who's the king? Who's the king? Who's
But
the king? Who's the king in a Christian world but Jesus?
exactly, but I don't. I like to use the word heir instead of sovereignty. Sovereign. I'm an
Yep,
heir.
yep, absolutely. It's a much more modern and more pleasant term to use that still asserts the same thing.
Exactly.
I am an heir as a child of God. I'm an heir to that throne in heaven, and that's where I'm going back to as prodigal son. That
Exactly.
is that is my estate. So it goes on and
Hey
says,
there.
go ahead.
I was just saying, hey there.
Greetings, greetings, and we got Iman with us again too. How you doing, sister? You there? Iman, Iman, say hi. Maybe she's. Can you hear us, Iman? Well, she can't hear us. We're gonna kick her from the studio, and hopefully she'll come back. Okay. It says if the actor is performing a discretionary action, then there is no immunity. So what happens here is when we've got the police that are out there using their discretion because they don't know the law, they're given immunity. Forgive them, for they know not what they do. So again, it goes to the first duty in law is legal notice. And that legal notice is that they're in a moral obligation under God pursuant to Article 15 of the Libra Code. They're the ones that are in armed conflict on the land. Third test, planning versus implementational. Remember that 48 CFR 52.212-5, contract terms and conditions required to implement. If the was the actor planning an action or implementing an action? If the actor was if the actor's planning of policy results in harm, then there is no immunity. If the harm happens due to the government implementation of the plan, then there is not immunity. If the actor's planning of policy results in harm, then there is immunity. If the harm happens due to the government's implementation of the plan, then there is no immunity. Go ahead.
Yeah, everyone actually has to file for the oath of office of every one of the elected officials in cities,
brother,
counties, and states.
you really got to fix that mic. There is something terribly wrong. We're not getting anything you got. Greetings, Iman. How you doing tonight?
All is
Did
well,
that work?
brother. All is well.
Good deal. Good deal. Glad to hear. Glad you're with us. Try that again, Rebel.
My side's echoing. Can you hear me?
You're still breaking up, brother. So we'll get back into it. The next one, the last one, is what we're talking about. Non-justiciable and justiciable. If the action is justiciable under regular tort principles, then there is no immunity. If the issue is not justiciable under regular tort principles, then there is immunity. This goes to this one here where the government implementation, then there is not immunity. This is the executor daison tort. Justiciable. Judiciability refers to the types of matters that a court can adjudicate, period. If a case is non-judiciable or justiciable, then the court cannot hear it. I'm not subject to the courts, not the Article I courts. Therefore, they can't hear it. It's a matter of correction in the records. And if they continue to do this, 94 cases so far, then it continues that pattern of practice of being justiciable. Justiciable rulings usually arise either when a court does not have power to hear the case under the Constitution, or it is imprudent to exercise judicial power. This is what they're doing. They're exercising judicial power in administrative courts, and that's non-justiciable. Specifically, the court must not be offering an advisory opinion. The plaintiff must have standing. The parties must not be feigned or collusive. The conversion of a last name to a firm name is a feigned condition. It's not real. I didn't know about it. It was a conversion without my knowledge, and therefore it's a feigned presentation of a corporate entity that doesn't exist. The parties and the issues must be ripe, but neither moot nor violative of the political question doctrine. Typically, these issues are all up to the discretion of the court, which is adjudicating the issue. Typically, these issues are all up to the discretion of the court, which is adjudicating the issue. Advisory opinion. An advisory opinion is a court's non-binding interpretation of legal question. That's what they give me in all 94 cases, was a summary opinion or a summary judgment, which is merely a summary opinion. Look at all the case laws. They're all opinions.
Right, because they're incapable of giving you a final judgment.
Yeah, you're the only one that can make a final judgment.
Exactly.
You have to make a declaratory judgment that rebuts the summary judgment, and then when they acquiesce, you can enter a final judgment. Once that final judgment is issued, now you can go after them for through order of execution, which is to retrieve the property that you're requesting out of that final judgment, whether it be monies or specific property itself. Under Article 3, Section 2 of the Constitution, a federal court may only adjudicate an actual controversy. This is referred to as the Case and Controversy Clause. Some state courts are allowed to issue advisory opinions under limited circumstances. However, these circumstances are typically enumerated within the state's constitution. Feigned and collusive cases. The case must have two genuinely adverse parties because a court's function is to resolve disputes. The parties cannot be fictitious or collusive. Oops. That means by using that fictitious name in the Article I courts and not the actual name in grammatical correctness in concise English, sorry, that's a feigned defendant. And a feigned defendant as an abstract noun, which means it's a total fiction. Go ahead, sister.
And that means all their shenanigans are null and void.
Yep. Voidable. Standing. Standing refers to the capacity of a plaintiff to bring suit in court. Typically, the plaintiff must have suffered an actual harm by the defendant, and the harm must be redressable. Ripeness. A claim is ripe when the facts of the case have matured into actual controversy. In other words, they go beyond the opinion of the court, and you can actually prove that there's something inconsistent and controversial. That starts at the beginning, and nobody ever mentions it. I'm sorry. I understand I was conferred a nationality of United States citizenship. I also understand that it's a United States business. And you know, I also understand I'm supposed to qualify for a permit to do business under 12 U.S.C. 614, wherein I have to have a communication with the Federal Reserve or with my organizational documentation, naming my board of directors and all that. And I've never done so. A case is not ripe if the harm to the plaintiff has not yet occurred. It occurs at enumeration at birth. It creates a controversy. The controversy being, is that infant qualified as a federal, state, or municipal officer or agent whose resident presence is deemed necessary by the board? And again, like I said, can he actually run a United States business? Does he have a permit to do business? Nope. So that creates a controversy before you're even educated about it, and therefore you have a not knowing of what's going on because nobody ever explains it to you. Mootness. A claim is moot if the relevant issues have already been resolved. Political question doctrine. Under the political question doctrine, a court will refuse to hear a case if the relevant issues are politically charged. Has nothing to do with politics for me because I'm not a politician. I've never registered to vote. I don't vote. I don't give a fuck about them two parties because they're bipartisan, acting on the same plate with two different objective views to create division among the people to believe that they are political. You are not political bodies. You don't have an oath of office. So back to the sovereign immunity. Citizens suing other states. In Chisholm versus Georgia 2, U.S. 419, 1793, the Supreme Court found that a citizen of a state has the ability to sue State B. However, this rule was later superseded by the 11th Amendment, which states that the judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. As such, citizen of State A can no longer sue State B. So let's take a look at the Constitution and see what it says. Article 3, Section 2, Clause 1, 13.4, suits against the United States and sovereign immunity. The judicial power shall extend to all cases in law and equity arising under this Constitution. In other words, anytime you have an issue or controversy with one of the public officials that took an oath to the Constitution, this kicks in. The laws of the United States and treaties made, or which shall be made under their authority, to all cases affecting ambassadors or other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies in which the United States shall be a party, joinder of the United States in the interest on the obligation of the United States and for the account of the United States. 50 U.S.C. 4305b2, full acquittance and discharge so that no person shall be held liable in any court under indemnification. To controversies between two or more states, between a state citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign state citizens or subjects. In addition to suits brought by the federal government as a plaintiff, controversies to which the United States shall be a party may include cases brought against the United States as a defendant. In addition to suits brought by the federal government as a plaintiff, amicus curiae, friend of the court, quia temet, a mistake has occurred, qui tam, in the name of the United States, we bring joinder as a United States as a plaintiff with us against the state who has violated tort law. May include cases brought against the United States as a defendant. Those cases fall within Article 3's grant of federal court jurisdiction. However, the doctrine of sovereign immunity may limit such suits. While state sovereign immunity is rooted in part in the 11th Amendment, no provision of the Constitution expressly grants the federal government immunity from suit. So don't give me this fucking bullshit about case law and their opinions that they have qualified immunity. That's bullshit. That's unconstitutional. Instead, most judges and commentators agree that federal sovereign immunity is a common law doctrine drawn from pre-founding English law, as it said earlier. Since the early years of the Republic, the Supreme Court has repeatedly adopted the position that the United States may not be sued unless it consents. It's still a republic, folks. They've never amended it. All you got to do is learn it and enforce it. What do you got, sister?
Well, the only thing I got to say to that, brother, is that unless the United States is a ventriloquist and can speak, that's the only way. But it is what it is.
Yep. I got Michael York on my birth certificate. My mother signed her married name under informant. Does that nullify the blind contract? No, it does not. Matter of fact, with that mother's maiden name, it helps solidify what Brian Parker and I were talking about earlier. Your next of kin isn't your father. And that's an attachment. See, your father's seed, your father's sperm, is the fertilization of the mother's seed. And that's what grows inside the womb. That's what's rendered in the womb, is the seed. Dad just fertilized it. Your next of kin is mom. And it's supposed to be your mom's lineal name. So as we continue on, it says the court has applied the doctrine of sovereign immunity to bar suits from proceeding without consent against the federal government for action of its agents or employees, and against federal agencies and government corporations. The court has further held that any waiver of sovereign immunity must come from an act of Congress. Executive officials are powerless either to waive such immunity or to confer jurisdiction on a federal court. In the 2019 case, Thacker versus Tennessee Valley Authority, the court rejected a separation of powers challenge to a statute that waived the immunity of a government-owned corporation. The court rejected a separation of powers challenge to a statute that waived the immunity of a government-owned corporation. Congress has waived federal sovereign immunity, though statutes such as the Administrative Procedure Act, the Federal Tort Claims Act, the Tucker Act, and the Fair Credit Reporting Act. Regulation Z. See? And again, if anybody thinks I don't know what I'm talking about and has something to help correct me on, please let me know. I don't want to sound like an idiot, but that's why I do my research, because I think I'm pretty sure on this stuff. In the absence of a waiver of sovereign immunity authorizing suits against the government itself, the Supreme Court has at times allowed suits to go forward against federal officials sued in their individual capacity. For instance, in Bivens v. 6 unknown named agents, unknown named agents. This is what we were talking about earlier with the identification theft and the Espionage Act. If they come out after me and they don't know who I am and they require me to ID and they expose a confidential agent, they're in trouble. And its progeny. The court allowed individuals to sue federal agents directly under Constitution without a federal statute authorizing relief. More recently, recent Supreme Court cases have construed Bivens narrowly. Then it's got all the sources. The next one is the Justice Department, Department of Justice. Justice Manual, Civil Resource Manual, 11 U.S.C. 106B. That's the Bankruptcy Act. Note, the Bankruptcy Reform Act of 1994 recodified as subsection 106B what previously was subsection 106A. Thus, different references to this subsection may appear in cases depending upon when they were decided. This subsection waives sovereign immunity where the estate has a claim against a governmental unit and the governmental unit files a claim against the estate. The claim against a government unit is property of the estate, and the claims of each arise out of the same transaction or occurrence. That's your administrative courts. Probating the estate, and the government's making a claim against your estate, and converting the data elements as if though that estate is being administrated for commercial investment, and that you aren't in fact alive. That you're merely just a authorized representative of the estate, and the claimant is nowhere around. The estate has a claim against the governmental unit, not me. The estate, as expressed in their documents, Keith Orton Little, all uppercase. Rationale: it would be unfair for a governmental unit to receive distribution from the estate without subjecting itself to compulsory counterclaims which the estate possesses. Scott versus McNeil. Court of probate has no jurisdiction over the estate of a person who is in fact alive. And yet here they are, continuously administrating an estate that they have no jurisdiction over, even though when I go into court they ask, "Are you Keith Little?" Huh? Do you see the problem here? Scope. 106 applies to monetary relief against a governmental unit. Code defines claim as a right to payment. Thus, 106B does not waive sovereign immunity for declaratory or injunctive relief, as we spoke of earlier. The governmental unit must file a proof of claim. In other words, they must be able to file a proof of claim that they have the right to administrate the estate, and they can't do that if you're alive. Because all you got to do is say, "Hey, wait a minute, I'm right here. It's my estate. I'm the testator. I'm the one that will testify on that stand. I'm the big boy with the big kahunas." Previously, the waiver of sovereign immunity was for compulsory counterclaims. Did not, on its face, requiring the filing of a proof of claim. However, the legislative history of the Bankruptcy Reform Act of 1994 is clear. Section 106B is clarified by allowing a compulsory counterclaim to be asserted against a governmental unit only where such unit has actually filed a proof of claim in the bankruptcy case. This has the effect of overruling contrary case law, such as Town and Country in reference to Gribben. Mere filing of an answer, not an express waiver of sovereign immunity, even if the answer fails to raise sovereign immunity as a defense. So whether you mention sovereign immunity or not, you can still raise sovereign immunity at any time. This is the same thing as questioning jurisdiction. At any time. Even after the case has been adjudicated, the suspect or defendant convicted, sentenced, and served that sentence. I can still go back and claim sovereign immunity because of the controversy. The claim against the governmental unit must be property of the state, of the estate. It has to be my intellectual property. That's why I keep telling everybody, you cannot have somebody else do this for you. It's a matter of knowledge, and you must learn how to do it. Otherwise, people are just going to keep taking advantage of you. And that's why I say we need to start teaching this stuff. As soon as we learn it, we need to start teaching it. And it is rather simple. I've got 8 years of study here that would have made it a lot simpler had they taught us this stuff in school. Instead of teaching us literary arts. Those are artistic things, which should be of our talents, which we gain from knowledge. Always, knowledge has to come first. Always. IRS versus Germain. Johnson versus Commodity Credit Corporation. Claim for damages based upon alleged improper post-confirmation set-off, not property of the estate, and thus no 106 waiver applies, because the state ceases to exist upon confirmation of plan. No waiver for action by bank alleging conversion of its cash collateral by debtors post-petition transfers to IRS because claim against the governmental unit, not property of the estate. So it's always got to be property of the estate. You always have to claim that property of the estate. What is the property of the estate? All real and personal effects. Fireman's Fund Insurance Company versus United States in reference to Boston Shipyard and Banker D. Mass 1987. By filing proof of claim, U.S. did not waive sovereign immunity for suit against it by performance, bond, surety. And then, again, that goes same for the man. If the government can claim qualified immunity, then so can the man. If the government can claim sovereign immunity, so can the man. Claims must arise from the same occurrence or transaction. And that same occurrence or transaction are those administrative transactions right from the enumeration at birth. That's an administration. The analysis used to determine whether two claims arise out of the same transaction or occurrence is the same as that needed to determine whether a claim is a compulsory counterclaim under Federal Rules of Civil Procedure 13A. Counterclaim and cross-claim. A. Compulsory counterclaim. A pleading must state as a counterclaim any claim that, at the time of its service, the pleader has against an opposing party if the claim arises out of the transaction or occurrence that is the subject matter of the opposing party's claim and does not require adding another party over whom the court cannot acquire jurisdiction. Exceptions. The pleader need not state the claim if, when the action was commenced, the claim was the subject of another pending action, or the opposing party sued on its claim by attachment or other process that did not establish personal jurisdiction over the pleader on that claim. That's their problem, folks. They have no immunity because they never obtain personal jurisdiction. None whatsoever. Damn it. Hold on. My apologies. In the meantime, I'll remind everybody, please hit that like, share, and subscribe button. And there's a PayPal link in the details section for anybody who wants to share some love. Always appreciated. Personal jurisdiction refers to a court's authority to adjudicate the rights and liability of the defendant. Before a court can exercise power over a party, the U.S. Constitution requires that the party has certain minimum contacts with the forum in which the court sits. Obtaining personal jurisdiction. Typically, for a court to have personal jurisdiction over a defendant, the plaintiff needs to serve the defendant in the state in which the court sits, and that's what brother was saying earlier about the service alongside the road. That's not proper, valid service. Diplomatic channels of notice, 22 CFR 93.1. 93.2 talks about notice of suit. And the defendant needs to voluntarily appear in court. Federal Rules of Civil Procedure Rule 4K describes whether a state's courts would have the authority to adjudicate a claim as it relates to personal jurisdiction. And that's that waiver of personal jurisdiction. That is a must. They have to give you a waiver of personal jurisdiction. Otherwise, if you walk into the court, it's presumed that you're waiving personal jurisdiction. And that still remains a presumption. You can still go back and claim that sovereign immunity. Let's go back. The analysis used to determine whether two claims arise out of the same transaction or occurrence is the same as that needed to determine whether a claim is a compulsory counterclaim under Federal Rules Civil Procedure 13. Claim for violation of discharge injunction arose out of same transaction or occurrence as state's proof of claim. I want to see the state's proof of claim in every situation that the state claims to be the plaintiff. Debtor's claim against one state agency arose out of same transaction as claim of another state agency. So the state agency of the municipal police force that issued the citation and then handed it to the court, and then they brought it in the name, the plaintiff, state of Iowa. Oops. Trustee cannot assert tax refund claim as compulsory counterclaim to IRS proof of claim after proof of claim has been denied. So who has to have the proof of claim, folks? Anybody?
I would think the proof of claim would have to be the injured party, which would be the living soul. Am I correct?
It's telling us right here. Read it. The state's proof of claim.
Right.
Not me, but the state. And who has to provide that proof of claim? IRS. Everything's a tax issue. Like I said, after I had that failure to appear dismissed, they issued me a document saying that the costs are taxed to the defendant. I'm sorry, I didn't know I was a taxpayer. Even after I told you I've never registered to vote and that I'm not a resident and I'm not a United States citizen. So what they're doing is they're still trying to use the Social Security number as if though I'm a fucking taxpayer. I told you, I gave you a statement of separation, and I didn't give you that Social Security number this time. You used that out of an old record as if though I gave it to you again for this occurrence. Sorry. That's what they're doing, is they're using the same number, occurrence after occurrence after occurrence, and it all stems from one occurrence, the enumeration at birth, which was an administrative process deeming me a resident that wasn't so at the time. That's the claim.
So the claim, if the claim is with the state, right, Keith? And the United States is the supposed indispensable party, what does that make the state? Is the state trying to attempt to become the beneficiary?
The state is posing everything in their interest.
Oh, okay.
They're saying they're the interested party. You're the investor. See, they swapped me as the investor and said that they're the beneficiary as an interested party. No, 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 no. You're stating you're the interested party when in fact the principal party in interest is the United States, and the real party in interest is myself. And the principal party of interest is the United States because they're the ones that are obligated for all securities, all bonds.
So that's where the subrogation came in. That's the switch.
Now we're looking at Foreign Country Money Judgments Recognition Act. The Uniform Foreign Country Money Judgment Recognition Act provides updated rules and procedures for the recognition of money judgments rendered in other countries. For further information about enacting the UFCMJRA, please contact Legislative Program Director Caitlin Wolf. Huh. Okay, well, I don't know why that's not working. But you'll notice these blue ones. These all have their own Foreign Country Money Judgments Recognition Acts. Why these others don't, I don't know. But we're going to take a look at the Iowa. I always like Iowa code. They seem to have the superior language and stuff, and it seemed to be first in line when it comes to this stuff, which of course wouldn't be without reason. The Des Moines is the state capital, and that is the origination of the Lawyers Guild way back when, 1869 or something like that. This chapter may be cited as a Uniform Foreign Country Money Judgments Recognition Act. Foreign country means a government other than any of the following: the United States, a state, district, commonwealth, territory, or insular possession of the United States. Any other government with regard to which the decision in this state as to whether to recognize the judgment of that government's court is initially subject to determination under the full faith and credit clause of Article 4, Section 1 of the Constitution of the United States. Any Indian or Alaskan Native tribe, band, nation, pueblo, village, or community that the United States Secretary of Interior recognizes as an Indian tribe. And as Steve Martin talked about here last week or so, we're talking about an indigenous government. Foreign country money or foreign country judgment means a judgment of a court of foreign country. Applicability. Except as otherwise provided in subsection 2, this chapter applies to a foreign country judgment to the extent that all of the following apply to the judgment. It grants or denies recovery of a sum of money. Under the law of the foreign country where rendered, it is final, conclusive, and enforceable. Give unto Caesar what belongs to Caesar. Give unto the Father what belongs to the Father. Pretty interesting. Because that Foreign Country Money Judgments Recognition Act is Revelations 18, verse 6, King James Version. And we have reward her even as she rewarded you. and double unto her double according to her works. In the cup which she hath filled, fill to her double. So what's that saying, folks? Do you understand what that's saying?
Yeah, to me, that it seemed like they're talking about the double portion, and that portion is, to me, it will be not only your integrity or credibility, but your love for your brother and your sister.
So what happens
I
if you got two cups and you try to put it all in one?
Yeah,
you
exactly.
can't. It'll overflow. It'll overflow. So that's why I
Where's it
love
supposed to overflow?
overflowing.
Where's it supposed to overflow? It's
Into
supposed to go back to
your
source.
neighbor's. Mm-hmm.
Right, to source, exactly.
So if I give them double, what do I get back?
Double.
Half of
Double.
what
You
I,
should get back a double
no,
portion.
no,
No?
I gave them double, so I get back what I gave them.
Right, you get back exactly. Makes
Okay.
sense all the way around.
So if their bonds, if their surety bonds, um, cover, what was it? Let me pull this up. I gotta pull my bookmarks. Give me a minute here. I gotta go all the way down this list of bookmarks.
While you're saying that, brother, I just want to make this, it's just incredible because between the breaks, I was just saying, I had just mentioned, give unto Caesar what is Caesar, give unto the Most High Creator God what is the Most High Creator God. And here you come right behind me with it. I can't make this stuff up. I love you, brother.
Synchronicity, sister, synchronicity. I'll have to show you guys.
Indeed.
I'll have to show you guys my bookmarks one of these days. I'm still scrolling through them, trying to get down to the bottom to some of the recent ones because I know the other day I posted a thing about the uh, surety companies and their list of certified companies. And under this list of certified companies, let me pull it up. Oh, that was this. Oh, yeah, it is. Yeah, it is. So let's look at the. Okay, we're talking about Travelers, right? And I don't know which one it is yet, but Travelers Casualty and Surety Company, 773,000, or excuse me, 773,873,000. Come on. $773,873. One, two, three times 2 equals 1,547,746,000. So I can write a bond up for twice that much. And guess what?
And the change
Revelation,
come back to you.
indemnification. So any time that they try to go against me, their surety bond company is going to say, wait a minute, this guy's got a bond twice the size of us. We better give him what he's demanding. And they'll write me a check. I'm pretty sure. 224,944,000. Double it. Whichever one they're using. 54,505,000. Double it. So whichever one I find out that they're using, I'm going to double it. And remember, that's a valuable bond. So all I have to do, and I have to be able to do it, place the value on it. This is where I'm getting the value. 18 million, 32 million, 46 million. So we're talking about a large sum of money that will allow them to go ahead and just pay you out anytime you want. Five CFR, Administrative Personnel, Office of Government Ethics, Executive Branch Financial Disclosure Qualified Trusts, and Certificates of Divestiture. That's what we're talking about. It's a certificate of divestiture. The various model trust documents and certificates of independence and compliance referred in this part or in this subpart, together with the underlying regulatory provisions, are all approved by the Office of Management and Budget under control number 3209-0007. And I don't know where these two came from. And then my last one here. Remember we were talking about 7 U.S. Code. When I come forth with this project about Hitler's willing executioners as a local program of learning, it's competitive, special, and facilities research grants. In order to promote research in food, agriculture, and related areas, a research grant program is hereby established in the Department of Agriculture, Competitive, Special, and Facilities Research Grant. There is established Department of Agriculture and Food Research Initiative. This is what we're talking about, is that food sovereignty. We're talking about our manna, that which feeds us and keeps us lively, which only comes from God and his wife, Mother Earth, and that's who we're supposed to tender. We're not supposed to be tendering these corporations. That's for those who want to bind themselves in that bonded servitude in suretyship. So let me show you something about all these public officials. Where is it? Let's try this. He who hateth. Here we go. Proverbs 11:15. He that is surety for a stranger shall smart for it, and he that hateth suretyship is sure. I assure you, I don't need to be insured. That's in suretyship. Can't do it. I fear not, for I have been redeemed. He has called me by thy name. I am his. That I am sure of. And with that, we finally come to the end of our birth certificate bond for indemnification, because that grants the ability to throw off the government and its suretyship. We don't need their government. We have a greater source of law. And that's all I'm trying to do, is correct the records. Mark Polo says, yep, I have them defaulted. I cashed them out. They work for me. I have them. What do you mean, Mark? Marco, tell us. We need all the information we can so we can come together on all this and make sure that it's valid. Let me drop the link in case you can come up on panel and discuss it with us. We got Josh Jonio down there as well. Greetings, brother. How you doing? If you're talking about checks from the surety company, please come up and tell us. We always like to hear success stories. I haven't had any yet, but I got 94 cases sitting down there.
Oh, they're
Yep. Yep.
Hey, Chief, I just wanted to add, while we're speaking on sovereign immunity and diplomatic immunity, I love the way you reference the Bible with all this stuff. And it just made me look up the word diplomat in Black's Law, which they don't have, but they have diplomatics, which is, let me go to it. The science of deciphering ancient writings.
Catching on, aren't you? Looking into them words.
Yeah,
That's why
cool.
it's important to rightly divide the word of truth. And the only way you can do that is by going back when the words were true. Only way. Okay. Well, if that's all we got, let us know what you got on the way out, folks. And like I said, I always appreciate everybody's support. Please hit that like, share, and subscribe button. There's a PayPal link down below for anybody who wants to share some love. Always appreciated. What do you got, guys?
Well, the last thing I want to say, brother, now I'm overstanding very well, and today is just a it's just a spiritual day for me, and it's so right because now I'm overstanding why my one brother, and now I'm overstanding why we were named a certain way. All my siblings and I, and my baby brother, he ascended early, so he was the one to ascend and sit on the left side of my father, where my other brother ascended, just recently, and he was the one with his calling to ascend on the right hand of his father. So both my brothers ascended and took their place with their creator. I yield. It's fascinating.
Yeah, it's amazing how language works. I did some research into my name, my biological name, Keith Orland Conrady, and German and Scottish descent. Definitely, the Conrady is definitely German. Keith is Scottish, and Orland is German. And Keith means man of the woods. Orland is another version of Roland, which means renowned across the land. And Conrady in German means man of the law. So it's a man of the law renowned across the land that came from the forest. It's amazing because I was born in Dubuque, Iowa, on the mighty Mississippi, and I've been an outdoorsman all my life. I love the mighty, muddy Mississippi running through my toes. I love it. I love being outdoors. I am a man of the woods. And I got 94 cases, so I'm kind of known in the area. And now they're going to know the law. Coincidence or what?
Well, it's crazy that you said that, beloved brother, because as a child, I did not like my calling. And only until I realized, when I looked it up and realized what my calling was, my first calling was the child of God. And my next calling was divine. And now it just, I've just journeyed this land just freely as my home. And I've always been walking with the Most High. So it is what it is, brother. We
Yep.
don't get our callings just because. We get it because we have a specific assignment through the Most High, and I yield.
Absolutely. We get everything from the Most High. Absolutely. And before we go, I forgot I wanted to pull this one up real quick. This is the James William Trust. This is filed with the SEC, as you can see, United States Securities and Exchange Commission, General Form for Registration of Securities, James A. William Trust, an express trust, revocable, because it says James A. Williams Trust. So it's been expressed, and it's during his lifetime, and he can amend it anytime he wants, as he states in this registration. So this is the very thing we were talking about with revocable and irrevocable trusts. And we see here, it says, title of each class to be registered. Birth certificate bond, and it's got the 10-digit, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10-digit number here on the birth bond. Individual surety bond, international bill of exchange, international promissory note. Now we're going to go down here, and this is all of his statements and stuff, but I'm looking for a particular thing. Let me see. And I've mentioned UNCITRAL before too. This is the international contracting stuff that led me to this, which when I read it, the way I read it is that when you buy something, what you're actually buying is the liability insurance. You're becoming the liable party because you're not signing right. That's what led me to all of this. And that was years ago. The company is also authorized by its ownership and control of 4 secured debt obligations. I've got 3. He's got 4. In the amount of $1,197,293,273 US dollars. So don't tell me I don't know what I'm talking about. The next one is 24 million, and the next one is 8.5 million. So he's got one for 1 billion, almost 200 million, one for 107 million, one for 24 million, and one for 8.5 million to offer for sale to any accredited investors. The secured debt obligations represent a creditor relationship that the company has with each of the 4 lien debtors. The marketable securities are available for sale and are shown on the company balance sheet at fair value. He's got one for sale for 1 billion. You want to buy it? See, he's investing in himself. This is that Revelations 18:2 or 18:6. The beneficiary for the company had made a valid claim of debt by an affidavit in the form of a commercial lien, and by allowing the lien to mature in 3 months into a secured debt obligation by the failure of the lien debtors to contest the lien and its affidavit by a counter affidavit. Acquiescence, folks. Acquiescence allowed him to file this with the Securities Exchange Commission. Tell me I don't know what I'm talking about. Please fix me. The security consists of several bonds packaged together with one underwriting, the other creating one package security. One underwriting the other, creating one package security. So this one is an underwriting for this one, which is an underwriting for this one, which is an underwriting for this one. I imagine it's municipality, county, state, and federal. Oh, and guess what? He gives your phone number. I think I'm going to give him a call. How better to do your research than ask somebody that knows? So with that, we come to our end. You guys, anything on the way out?
No, thanks again. Thanks again. I'm gonna watch that video yesterday you did on the journal. That was a good one. I like that one.
Yeah. Absolutely. There's a big difference between journaling and ledgering. And one is a private journal and one is a public journal. And when they commingle private with public and then put it on a general ledger, there's something seriously wrong. That's commingling property of the estate. And the beneficiary has the right to follow trust property when confused with other property. And that's what we're talking about.
Right. And in that video, you said they're not even supposed to be speaking with us.
Nope.
And that goes back to when they first arrest us, they let us know we have the right to remain silent.
Yeah. Yeah, I'm sorry, I can't talk to you. Absolutely. So anyway, with that, you got anything else, Iman?
No, all glory goes to the Most High, and we just keep coming together as brother and sister in this fight.
Absolutely.
Freedom, that's it.
Absolutely. I feel more and more blessed every day. So let's keep coming together. Let's keep doing this, and we'll see how it goes. And one day we will be successful in counteracting all this stuff, so we can actually teach it to other people consciously, concisely, and effectively. And with that, you guys know me. I love you, but I don't give a rat's ass whether you love me back or not. That's to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good day. We'll see you next time.